Good evening, folks, and welcome to another session on the Wise Asylum. Oh, we're into March. Whoa. Now, you guys are aware of Chris Hauser. I know this. So, as I said before, I just pointed out what I thought were missing in a lot of his stuff is he doesn't put it across, or he didn't, that it were important you understand if you're moving as beneficiary, you can't be acting as trustee at the same time. We made that clear. I think it's been made clear by Chris himself. So you're on with that. But now looking into the way that Chris moves in relation to how he would deal with anything in court, this is the insight you need to just pull together. So we've got a UK version and we've got a US version of how to use Chris Hauser's data in a nutshell, because we like simplicity, don't we? So in the UK, you would be looking to present in this way. So without prejudice, I, Sean, and then a colon, which you'd put young, comma, beneficiary. I'm here under fraud, menace, and duress, and thereby challenge jurisdiction. Fiduciary Cheryl, which is the judge, and then the judge's first name. Okay, because he is now a fiduciary because you've presented yourself as beneficiary. Okay. I am the living beneficiary of the Social Security SESCV Trust, Sean Young, and this is now a trust action, which you are now entrusted as a real party and interest to this action. Okay? This court is a colonial court of admiralty under admiralty jurisdiction. See the Colonial Courts Act 1890, wherein said act claims civil jurisdiction in every court of law in a British possession and or every court in England wherein said court has no jurisdiction over the said living beneficiary who is standing here before you. So that's how you'd use this, the guts of what Chris has given you on the beneficiary side. That's the UK. So get that in your minds, people, because that is something you would be wise either to keep on paperwork with you at all times in your carriage or in your horse. Or even better still, put it to memory. Now in the US, you would present it in the manner, without prejudice, I shall call on young, comma, beneficiary, I'm here under fraud, menace, and duress, and thereby challenge jurisdiction. Fiduciary Cheryl, and then the judge's name, I am the living beneficiary of the Social Security SESCV Trust, Sean Young, blah, blah, blah. And this is now a trust action, so it's the same. But the important bit for the Americans would be this court is operating under military admiralty jurisdiction and or maritime law. See title of the United States Code, Lawyers Edition, Interpreted Notes and Decisions. As placing a fringe on the national flag is within the discretion of the President acting as Commander-in-Chief of the Army and the Navy, wherein said court has no jurisdiction over the said living beneficiary who is standing here before you. Okay? So those are your two, the guts of what Chris has given us, because but pulled into simplicity in relation to how you would affect your standing at any time you're in court. Of course, I would always promote the statutory declaration, but I know it's not easy for people to come to grips with it. But I am here to help for anybody who's serious in using that instrument. So that, ladies and gentlemen, is exceptionally interesting information. Now we can just further that. We will look now at, so this is the Magistrate Court Act 1980, Chapter 43, Part 7. Now, its constitution and place of sitting of court. Okay. Now, 1. A magistrate's court shall not try an information summarily or hear a complaint except when composed of at least 2 justices, unless the trial or hearing is one that by virtue of any enactment may take place before a single justice. 2. A magistrate court shall not hold an inquiry into the means of an offender for the purposes of section 82 above, or determine under that section at a hearing at which the offender is not present, whether to issue a warrant or commitment except when composed of at least 2 justices. So warrants can't be issued unless it's 2 sitting with 2 justices. And 3, says F2, and then 1 F3, 4. Subject to the provision of any enactment to the contrary, a magistrate court must sit in open court if it is trying summarily an information for an indictable offence, trying an information for a summary offence, imposing imprisonment, hearing a complaint, or holding inquiry into the means of an offender for the purposes of section 82. Okay? So that's your cash. They can't do that. It has to be 2. So all these warrants that are coming around to your doors with these numpties, that's why you need to remind the police. And then it's game over for said numpties. Not the police, the dicks that are trying to play the game. So that's how you stop the police from even if they're assholes, because some are, from supporting the bailiffs. Now 5 is important. It says, a magistrate court composed of a single justice shall not impose imprisonment for a period exceeding 14 days or order a person to pay more than £1. So if you're ever in court and it's a single justice, 14 days, £1. That's it, maximum. And a magistrate's court that is trying a summary offence in accordance with section 16A is restricted to the following in dealing with the accused for the offence. So then there's further data that might be interesting to you from the Magistrate Court Act 1980. But that's very important that you understand what that's saying, because that is important when you're getting these loonies coming round claiming to be holding a warrant. And finally, in this section, an act, so this Admiralty law is civil law, okay? An act to amend the law respecting the exercise of of Admiralty jurisdiction in Her Majesty's dominions and elsewhere out of the United Kingdom, 25th of July 1890. Be enacted by the Queen's Most Excellent Majesty by and with the advice and consent of the Lords Spiritual and Temporal and Commons in this present Parliament assembled, and by the authority of the same as follows. So Lords Spiritual, of course, are your bishops, and Lords Temporal are the peers. This Act may be cited as the Colonial Courts of Admiralty Act 1890. Every court of law in British possession which is for the time being declared in pursuance of this Act to be a court of Admiralty, or which of no such declaration is in force in the possession as there in original limited civil jurisdiction, shall be a court of Admiralty. So they're telling you, as we looked at Hauser's work, where they don't have any power over the beneficiary present, because you're telling them that you know it's Admiralty, this is where you get it, that it is an Admiralty. So this is your backup for that, yeah? And it's just telling you that they are Admiralty courts, okay? So again, another piece of information and data that is important. What I'll probably do is put these documents, I'll put them up on as documents on the website and then put links to them. Hope that made a lot of sense to you.